Welcome to the Ask the Expert Show with local celebrity hosts Steve-O and Rene. Sit back each week while Steve-O and Rene educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Rene with today's expert in their field.
And we are here live.
Did you see the light?
No.
The light
What's
came
it doing
on.
down there? So we are no longer the Steve-O and Rene show.
We're not. What are we?
We're now the award-winning Steve-O and Rene show.
Oh, congratulations.
We
Yes.
just won New Times Reader's Choice Best AM Radio Personality.
We just found out right before we got here.
Oh, congratulations.
Thank you. Thank you.
Speaking of award-winning,
Yes.
we have a guest on our show. I know you're going to love doing this today because it kind of...
Well, I'm going through this myself with my
Yes.
family, so this
So-
is perfect timing.
Of course, we bring in the top of the top. We have with us David Shulman of Ginsberg Shulman, attorneys at law. Now, their main office is on Las Olas, but they also have a satellite office in Boca right here. So this is going to be a show. We're going to talk about wills and estate planning. And
Which everybody needs to get that in order. They do.
you're absolutely right because, you know what? A lot of people don't know. Even if they have a will, and we're going to talk about this today, about every 3 years you should have...
It's a good idea every 3 to 5 years, plus every major life change. That
What a life change would be.
a marriage, a divorce, a death in the family, and new children, that you got a new job, you lost your job, you moved from out of state. Anything that changes in your life, it's a good idea to think, and maybe I should have my documents reviewed to see if they're still the same people, to see if the taxes are still the same.
Do the taxes change on a yearly basis? This is what I'm hearing.
Well, the
estate taxes.
The estate tax right now, the estate tax exemption is the amount that you can die with before the estate tax kicks in.
So is it changed on a yearly basis?
It does. In 1999, it was about $600,000, meaning anything over that amount was subject to tax at 45%. And that includes your house, your retirement accounts. So it's pretty low. Right now, it's about $5.4 million. So if you don't have $5.5 million,
So you have to be under that amount to not be taxed. Is that what you're saying? Okay.
So 99% of the people
Don't have that, right.
don't have that problem.
Well, we just barely made it. We only have 4.5
yeah, okay.
million.
You should only be so
But
lucky.
let me have David introduce himself and tell us about your firm.
Oh, well, thank you very much. I'm David Shulman. I'm the managing partner of the firm at Ginsberg Shulman. We are a boutique estate planning and elder law firm. We're located in downtown Fort Lauderdale. Like you said, we also have another office in Boca on Glades Road.
Perfect.
And tell us a little bit about your background because your partner's not here.
My partner's not here. We'll get her here sometime.
We're going to have to get her here.
You know, one of us still has to stay in the office
Exactly.
working late nights. So I grew up in South Florida. I went out of state to school. I went to Brandeis for undergrad and GW for law school.
Nice.
Yeah.
Top
After law-
credentials.
After law school, I worked for everyone's favorite government organization, the IRS, for about 7 years.
You did?
I did.
Wow.
So
what
you
a
know
change
the ins and outs.
I tried.
That's
and
interesting.
Our firm has been for about 3 years. I've been in private practice for about 10 years. And I'm board certified by the Florida Bar in Wills Trust and Estates.
Oh, wonderful.
I
You
know
we have to open up the line to
Yeah.
our listeners also. So if you have a question about estates or wills, trusts, call us at 888-565-1470. That's 888-565-1470. So
Where
now I
should
have,
we
this is my
start?
first question for you because this is what, I just was talking to you about this.
Right.
My father had his lawyer come over yesterday, so we just went through this.
Your father passed away?
No, God forbid. God
sorry.
forbid. God forbid.
I'm sorry.
No, but there was a change over the years. He has not updated his will in 19 years. My mother passed away around 7 years ago. So the suggestion was, like you said, there was a life-changing event to update his will. So we were talking about the differences between an irrevocable will and a revocable. So explain to people, because I got an education
Or
yesterday.
between a revocable trust, you mean?
Revocable trust. That's exactly
A
it.
revocable trust is the purpose of a revocable trust is to avoid probate. And probate's the process of after you die, someone has to go to court to be appointed personal representative to manage your assets, to pay off the creditors, and distribute it to the beneficiaries. And it could be, in certain circumstances, very expensive and very time consuming. However, if you have a revocable trust, what you do is you transfer your assets to the trust, and the trust is a will substitute. So instead of the will disposing of your assets, the trust does. And what happens when you die, because the trust has the assets, it avoids probate. Now, that's a revocable trust, meaning that you can revoke it, you can change it, you can do whatever you want with it at any time while you're alive or have capacity. An irrevocable trust is often done for gifting and for tax purposes and for asset protection purposes, where you transfer the property away. Usually you're making a gift to someone else, or it's done to store life insurance policies, and that's an irrevocable trust, means you can't change it, you can't take it back.
So once you set, you can't ever change the will. So once it's set, you
That's
can't
right.
change anything.
It's very, very difficult.
So what's the benefit to doing that, except for tax reasons?
The benefit is for tax reasons and for asset protection. If you're gifting property, let's say you want to gift property to your grandchildren or your children and a large amount of money.
And what happens if something happens to one of those kids and then you can't change anything? God forbid, and you don't have anybody else set in that will.
Well, you set up the trust so it goes to someone else.
What happens if you have a fight with somebody?
Well,
You're screwed. Basically,
in some circumstances, it could be. So irrevocable trusts aren't as common as the revocable trust. The irrevocable trusts are done only in certain circumstances and really aren't the everyday trust for most people.
Okay, and how about setting up like trustees?
Trustees, it should be for a revocable trust, you're generally your own trustee first. So while you're alive and you have capacity, you're making those decisions. And then the successor trustee, depending on the size of the estate, is either a relative or a friend, or they're professional trust companies also for larger estates.
So do you have to live in the same state to be a trustee?
Legally, you don't. Sometimes it's helpful because the property is here and the beneficiaries are here, but it's certainly not necessary.
Okay.
I have a question. David, what do you do when a client comes in and they want you to set up a will for them, and then they start down the road wanting to change it and change it again? Do you just when they say I want to change it, do you get into, well, why do you want to change it? Are you sure this is what you want to do?
Well, I talk to them about a little bit. It's their will, it's their life. If they want to change it, they're allowed to change it, and nothing's written in stone. You can change things as much as you want. Now, I explain the consequences of changing it. Sometimes people get mad at one of their children and want to disinherit them. And I say, are you sure you want to do this? Remember, you'll be gone and they'll hate you forever. But people, sometimes it's well-deserved. Sometimes a child, can't handle money or is on drugs, so you want to put the money into a special type of trust. Or the child's successful, they're Bill Gates, and they don't need the money. Right. There are all sorts of reasons why people want to change their documents.
How do you go? What do you think? Well, how do you go by choosing an executor? What do you want to look for when the family's trying to decide who's the executor?
Well, in Florida, the term's actually called personal representative.
Okay.
It's the same thing. New York, other states call them executor, and Florida's the personal representative. It's the same thing. A personal representative has to be either a relative or a Florida resident.
Okay. So this is separate from a trustee?
It's separate for the trustee.
Okay.
The personal representative is in your will, the trustees of the trust.
Okay.
So the personal representative, if you have probate property, has to be either a relative who can live anywhere or a non-relative who's a Florida resident. Now, you have to. It's tough. You got to think about who can do the job. I mean, who's going to be responsible to marshaling the assets, paying the debts, investing the assets while the probate is going on, and then distributing them. The truth is that the attorney often does most of the work. We still have to have someone who can ably do the job and is going to be responsible.
Okay, my question is this, because you keep saying probate. So tell everybody what probate is and how to avoid probate.
Probate is if you die and you own certain types of property, that there has a court proceeding to distribute your property to your heirs, to your beneficiaries.
Just property only.
Well, what else?
Property, money.
Money. When lawyers
money
say
is included in the property.
Right.
Everything inclusive.
Yeah. When lawyers say property, they mean everything.
Everything.
Right.
Okay.
Real property, personal property, intangible property, stocks, bonds, your house, your car, everything.
Okay.
If it's not in the trust and there's not a beneficiary designation, sometimes things like a retirement account will have a beneficiary designation, or a bank account will have a pay on death beneficiary. Anything else has to go through probate. And probate's the process where a court oversees the distribution of the assets.
Do they take a portion of it?
The court doesn't, but the personal representative can, and the attorney gets paid.
Because look what happened with Prince. Because he never had a
Right,
will.
Prince didn't have a will. Now, Prince, remember I said the estate tax exemption is $5.5 million. Prince probably had $300 million.
Right.
So he's probably going to pay $150 million in estate taxes.
So if he had something set up, he wouldn't have?
If he had proper long-term...
Irrevocable.
Irrevocable trust,
Yes.
if he had proper long-term estate planning done many years in advance, it could have significantly reduced whatever his estate tax is through various techniques.
So do you also go into probate? Say like there's kids and your parents left you a certain amount of money and the other one hardly any money. Does it go in, if they're fighting, does the money go into probate?
That happens all the time. That if one
So even if you have like a trust, even if you have everything set up?
well, sometimes the kid who's left out is going to be upset and is going to sue. They're going to say that there was undue influence, that the kid who got the money unduly pressured mom into giving it all to them, and it was unfair, or mom didn't have capacity when she signed the document, then she had Alzheimer's, and the son went and made her do it. So sometimes, yes.
Do they win those cases?
Depends.
Sometimes they do, sometimes they don't.
And not only that, lawsuits are, whether they win or not, lawsuits are expensive.
Exactly.
And they take time too. It
And they
takes a long
take time.
And they still end up settling.
So
probably.
most of them end up settling because once you have a lawsuit, it's a
holds
problem.
up the tides of money for everybody.
That's correct.
Wow.
For years, possibly.
Wow.
So you don't want your monies going into probate or any of your
But
property.
you want to try to avoid probate as much as possible. But even when the trust, there still can sometimes be lawsuits if the kid is left out and doesn't feel that it was proper.
Oh, wow.
Let's talk about elder law, because you also handle elder law.
We do.
What is that? What is elder law? I mean, I kind of figure about age demographics,
Right,
but
there's elder law includes estate planning, and it's all the issues regarding the care and treatment of the elderly, with mostly their health care. Often, a nursing home in Florida costs $80,000 a year. Over
Wow.
80.
So it does? So what does Medicaid cover? Do they cover any of that?
Well, Medicaid can. That's what a lot of elder law is. Medicaid can cover a nursing home stay, but in order to get Medicaid, you have to qualify for Medicaid. When you're not allowed to have more than $2,000 worth of assets in order to qualify for Medicaid.
Really?
So long-term Medicaid planning, if done at least 5 years in advance, can set someone up so that if it's necessary, they can qualify for Medicaid and get into a nursing home.
and then there's also home care down the road. There's so many things to think about.
I mean, if you're in your 50s and you can afford long-term care insurance, it's very good to get.
Well, some of them are. Because I've seen some policies that are not fabulous.
Right, you got to be the right policy.
Yeah, exactly.
And they're not as good as they used to be.
Right.
Well, so this is hitting home a little bit with you. Elder law. When should and I'm actually now going back to wills. When should someone start planning a will?
Well, everyone, if you're over 18 and you have property, it's a good idea to have your at least basic estate planning documents
How
done.
in the world did Prince, with all of his money,
That's
all of his
so
managers,
surprising, right? It's like shocking.
how did he? I mean, do you ever see that with someone who has a lot of assets who hasn't had a will?
Obviously, it happens. It's crazy. You can tell clients what to do as many times as you want to, but in the end, someone's going to do their own thing. Prince was an odd guy, so.
Yeah, I guess. I mean, I can't.
So
believe that-
something? We're going to go to commercial
Yes.
break, and I want to come back and I want to ask you, what happens if you don't have a will?
Sure.
Because that's a big thing. A lot of people don't want to spend the money to have an attorney. They have family, they have children, and they don't want to spend the money to go and have a will done. So let's go to commercial break, and we'll come back, and David will answer that question. We'll be right back.
When was the last time your will was reviewed, or do you even have one? Do you know that without a will, the government decides how your property is distributed upon your death? Did you know that without proper estate planning, your children would receive every penny of their inheritance on their 18th birthday to use or lose without any guidance? The law offices of Ginsberg Shulman provide their clients with comprehensive estate planning, probate and trust administration, guardianship, business planning, and wealth preservation. They believe that planning for the future should not be left until the future. Whether you are young, middle-aged, or in retirement, your life is always changing. Comprehensive estate planning can protect you and your loved ones from the unexpected. When you experience a significant life cycle event or life change, it is a good time to have your estate planning reviewed. Contact their office today at 839-8705.
Light's not there.
Well,
we
there's
go.
the light.
I see the light. And we're sitting here with David Shulman. He's with the law firm of Ginsberg, Shulman. You can actually watch the show live right now at www.www.wwnnradio.
That's too many W's. It's wwnnradio.com. You don't need to use all those W's. It's too
Well, what
confusing.
about our elder people,
No, I'm just
though?
saying it's very confusing. Very, very confusing. People know to put the www.
But you can actually watch the show live, and I think you can actually go back and watch it on your website.
Tomorrow there'll be a video of the web.
Oh, good.
It's not streaming live on the website right now.
Okay.
We're working on getting that set up.
Good.
Tell everybody your website.
It's www.ginsbergschulman.com. Ginsbergschulman.com. But
Perfect.
tomorrow there'll be the recorded video of the website.
Good.
So if
now
people
here's
missed
something
anything-
I want to say. You know, here's Princeton have a will. There's people out there who, listen, we never know what's going to happen to us tomorrow.
Absolutely not.
And you know what? You start wondering, like, well, who should I go to? And people will start Googling.
Or it
for
used
an
to be they went
estate.
through the yellow
Right.
pages. And whoever
Yeah.
had the biggest ad, people would call them. Now people Google. And that's not the right way of handling
No,
things.
Probably not.
No, it's
No,
definitely
it's
not.
definitely
so
not.
We have, and just because he's the best of the best doesn't mean his prices are sky high either. I don't want you to scare you away, but give everybody your phone number.
It's 954-990-0896.
Okay, so we were talking before break
Right.
about the fact if you don't have a will and you own a house or a condo and you have some assets and you have children and you never set up anything for your kids, what happens?
If you don't have a will, that's called intestacy or intestate. That means dying without a will. And if you don't have a will, then the government decides for you how your property is distributed. Now, and if it can be very complicated. In traditional, Leave It to Beaver, 50-year-old families where it's the husband, the wife, of the first marriage, and the same kids, then it's pretty straightforward.
But that's not the case anymore.
That's not the case
Right.
anymore. And we got, when you're 20 years later, when we had the Brady Bunch, we had Mike and Carol, each with their own set of kids. It gets very complicated. And that's how many families are today. So take the Brady Bunch, for example. If Mike died without a will, then Carol would get half his property, and then his kids would get half his property. And then when Carol died, her kids would get all of her property, including the half she received from Mike, and his kids would get nothing. So intestacy can be very complicated, and it will have bad results or unintended results. In Prince's case, all his property is going to his siblings and half siblings, many of which he had no relationship with.
And people that are claiming that they're his children, they're doing DNA testing.
Well, if they find his children, then the children will get everything.
Oh. So wait a second. Wait. So it's usually the kids first. The kids get the money first.
Well, spouse first. Spouse and
If there's
no
no
spouse.
spouse, right.
Right. If there's no if it's spouse from a different marriage, spouse and their kids from a different marriage, and it's generally split between the spouse and the kids.
Oh.
And then if there's no kids, it's just the spouse. It's just the spouse.
So if it's the original spouse and children, the spouse gets it, and once something happens to the spouse, it goes to those kids.
Right.
Okay.
And if there's no spouse and no kids, then it goes to the parents. And if there's no parents, it goes to the siblings. And then it goes down to the siblings' kids, and it goes up and down. So in Prince's case, his parents he wasn't married. He didn't have any surviving children. I believe at one point he had a baby who died early. And so it's all going to go to his siblings and half siblings who he didn't
Have any relationship
and didn't have
with.
any relationship with. And he was a charitable guy.
Right.
And he'd probably want to give to charity. Nothing's going to charity. Half of it's going to the government.
But isn't this so surprising that somebody with such a large estate would do nothing, have no documentation?
It's crazy.
Or will? It really is.
You
Too
know,
bad I didn't get to know him. I would have got some money.
I know, but for people without Prince-size estates, if you're in a blended family where there's children, where the children aren't uniform or aren't
Right.
from both
And
spouses,
that's very typical
and
nowadays.
it's very typical. Most people I know are either through divorce or death or whatever it is. Then if you don't have a will, your property is probably not going to go the way you want it to.
Donald Sterling, who owned the Los Angeles Clippers, him and his wife both owned the team, and his wife took him to court and said, and this is more probably a guardianship,
Right.
said he wasn't of sound mind. that she should have all the right to do what she wants with the team.
Well, she didn't file for guardianship. I don't believe she did that.
I was not as familiar with the case.
Yes,
Did she
but
file for
had-
guardianship?
I
or-
don't believe so.
But she was saying that he had dementia and he didn't
And
know
that's a
what
good
his-
question. I want to ask that because that's a very good question. So you should do your will while you're in sound mind because as you start getting
Right.
older,
And not only that, when you do your will, you generally also do a power of attorney and a healthcare surrogate. So if you become incapacitated, if you don't have sound mind, you appoint someone to make decisions for you.
right?
Now, Donald Sterling probably would have appointed
Well, his wife was his partner.
probably would have appointed his wife, even though maybe at some point he would have taken it back.
Right.
So she was the one who could make the decisions anyways. They ended up settling the team for $4 billion.
Yes, exactly.
So it's not like he really suffered.
Yeah, right. But, I mean, that was like his baby. What's a $4
Right.
billion baby? But, I mean, she actually, I think, did the right thing because the NBA was trying to get him out. But the scary part is that she said he was
Incapacitated,
suffering from
yeah.
Right.
dementia. And I heard him do an interview, and it was actually very good. He didn't sound like he had dementia.
So what happens in that case? If somebody wants to change their will later on in life, do they have to go to see somebody to say they're of sound mind? If they come to you and say, "I want to make a lot of changes to the will,"
I'm not a psychologist, but generally I can tell. If someone comes to me, I sit and I talk to them.
You have to be a psychologist in what you do with all these family members fighting.
A little bit sometimes, but the thing is that there's a standard, and a person needs to know what their property is, understand what they're doing, understand who their children are. They don't have to be full rocket scientist.
no. So
mode.
it's just basic questions
Right.
that you ask them, and if they know what's going on, then you feel like they're of sound mind. Tell people what a power of attorney is.
A power of attorney allows you to appoint someone to make financial decisions for you. Pay your bills, open your mail, sue on your behalf, change your bank accounts if necessary. Anything you can do for yourself. That's what a power of attorney does.
Okay, so when does that come into play?
It used to be a power of attorney was springing, which means it sprang into effect or sprung into effect upon your incapacity. So you say, in the event I become incapacitated, I appoint Steve to make these decisions for me. But now they changed the law in 2011. The power of attorney is no longer springing. That means when you sign it, it's effective immediately. So
it is.
and there's nothing you can do about it. So whoever you appoint that day, technically, can take it and take your bank account and take all the money and go to Venezuela.
Okay, so what's beneficial about doing that? Why would you want to do that so early on then?
Well, one, you don't necessarily have to tell them. You don't have to tell the person you appoint that they have the power. Just tell them if anything happens to me, call my lawyer.
Okay,
But
because typically, like I'm saying, like
Right.
I've set up with my.
Because the problem is if it's too late, if you wait too long, and then something happens to you, you don't have the power of attorney, then you have to go in for guardianship.
Right. So this is the question because I was just doing my father, redoing his will, and he wants to set a power of attorney. But I mean, we know that we have power of attorney.
Right.
So
But you're his daughter. He trusts you. You're
Exactly.
not going to take all his money.
okay, so
Hopefully.
of course not, never. But I'm just saying. So why are you laughing? I'm just saying. No, of course
Right,
I
of
wouldn't
course-
be
of
doing
course
that.
not, right.
But typically, I would say most family
Right.
members would want to do that just in case as your parents start getting elderly,
Right,
and you want to have that set up.
And in most cases, it's okay. When they say it's my spouse, my child, I let them know what the danger of it, and they say it's okay. Sometimes it's it's a distant cousin or it's a friend,
Right.
And I say really think about it if you want this person to have the power. And then sometimes they say it's fine, and sometimes we try to think of someone else.
Okay. I want to touch upon this before we go off the air also. I know you do guardianships in your
We
office.
do. My partner is the guardianship expert. I do a little bit. My partner is the guardianship expert.
So there's a lot involved. And I know personally firsthand, unfortunately, because I am a guardian. I have guardian advocacy of my daughter. So tell everybody, I mean, this is why you want to have everything set up, especially
Right.
with the power of attorney, because you don't want to have to go through the guardianship.
A guardianship is a very expensive and intrusive process. When someone petitions the court to have you declared incapacitated, and the court makes the decision whether or not you're incapacitated, they send out an examining committee, a psychologist, a psychiatrist, and a social worker to see whether or not you're incapacitated. And if the court rules you're incapacitated, what it does is it takes your rights away. It takes away your right to contract, to control your own money, to determine where you live, and it appoints a guardian to make those decisions for you.
Like driving, can you drive anymore?
Probably
Vote.
not. All these are all things that they can take away. And the guardian can either be a family member or it can be a professional guardian. And what happens is the professional guardian gets paid. You're appointed. You get a court-appointed attorney. They get paid. The guardian has their own attorney, and they get paid. And they all get paid from your money. So not only are your rights taken away, people are taking your money and using your money to make decisions for you. Now, sometimes it's absolutely necessary. Sometimes that the person didn't plan and didn't have a power of attorney, or unfortunately, there's some sort of financial exploitation where the person they appointed is abusing their fiduciary authority and taking the money, and there has to be a guardian appointed. Guardianships save lives because people are incapacitated, they're making dangerous decisions, people are taking advantage of them. And guardianships aren't bad because they do save lives, but there really should be the last case scenario.
Right. Because if you could do the power of attorney, that's so much
Right.
more beneficial because people don't even know. As far as a family member is concerned, there's so much involved on the
Sure.
other end as well. Accounting, classes. I mean, it's a yearly
Right.
process that you have to file paperwork. And you were saying about an expense. It's a huge expense to do.
Right. My grandmother's in her 90s. She's Alzheimer's. She's in an assisted living facility. I have power of attorney. I've been paying her bills for years.
Right.
And and I make healthcare decisions. Now, if I had to do if I didn't have the documents, I would have to go in for a guardianship. I would have to file an annual accounting, an annual report with the court every year. It would be, the court would be looking over my shoulder. The
Yeah,
auditor,
you have to be fingerprinted on a yearly
Fingerprinted,
basis.
I've taken
Yes,
class.
background checks.
There's an audit department in the Broward County Courthouse who looks how every penny is spent.
Yes.
And asks, why did I spend this much or that much? Obviously, I know it's all going for her care, so everything's spent for her aid.
But that's not the point. It's just excess stuff. Now, another thing is that people don't realize is guardianships for children when your kid turns 18, and we were talking about
Right.
that before the show. If your kid is disabled, you have to file for a guardianship of your own child, which is
Correct.
a whole different thing.
That's different. Either a guardianship advocacy, like you were talking about,
Right, which I
do,
have.
which you can do by yourself, or if they're more disabled, you can do a full guardianship. And there's also sometimes if kids inherit property over $15,000, or they're settled if they're in a personal injury lawsuit and they get over $15,000, you also have to do a guardianship for the money.
We're going to have to get into this in more detail
I know,
next time he
but-
comes in.
I know it's fascinating. It's
Yeah,
amazing.
especially with the guardianships.
Give
There's so
everybody
much
your
involved.
phone number again.
Great. It's 954-990-0896.
And give them your website.
It's Ginsberg, Ginsberg, Shulman, SHULMAN.com.
I feel like we squeezed so much information out of him in
know.
this half hour
I know.
because there's so much to know. There really is.
Well, you're going to be back with us again next month. We're going to do our estate planning show, and we love having you on our show.
I loved it. It's a lot of fun.
Thanks
I
so
like doing it.
Yes,
much.
thank you,
again, the name
David.
of the law firm is Ginsberg Shulman. And we are going to have another show. We're going to be doing a public adjuster show in the next 30 minutes. So don't go away. We're going to go to break, and we'll be right back.
Thanks, David.
Thank you.